Okay, this is National Popular Assembly Civics class, and tonight's class will be dealing with Class 8 information, which is land titles and land registry. And I posted the information in Class 8 docs for the reading material, and we'll start tonight with, does feudalism have a role in 21st century land law? So I'll just read it and I'll just stop periodically to basically explain what's going on here. So this gentleman's an author from Law Commissioner from England and Wales. So it's English law, but it's important that you understand that what they're trying to do over here is just continue their feudal system, and you'll understand shortly into this article like what's truly going on even here, even though we're reading about what's going on over there. So the author, Law Commissioner for English and Wales, argues that following the example of the bill to abolish feudal tenure, now before the Scottish Parliament, it is time for major reform of the relics of feudalism still prevailing in English law. So right there in the beginning, they're telling you, making you aware that, guess what? Their land system is still feudalism over there. There is before the Scottish Parliament in Edinburgh at present a very important bill, the Abolition of Feudal Tenure, etc. Scotland Bill. It is intended to implement the Scottish Law Commission's report on abolition of the feudal system, 1999 Scott Law Commission, blah, blah. It is largely the work of Professor Ken Reid, who has responsibility for property law at Scottish Law Commission. As the title of the bill suggests, it will abolish the feudal system as it applies in Scotland. Okay, so this is the Scots basically saying, all right, really? Enough's enough. Maybe we should get rid of this shit. The thesis of this article is that an equivalent piece of the legislation is needed for English and Wales, obviously, but they're never going to give it up. Unless a revolution happens, then they're just going to have to give it up. Through though rather different reasons, it begins with an explanation of what remains in feudalism in English law. This remnant has absolutely no connection whatever to the logic of feudalism as it developed and cannot be justified. Well, it's never being justified from the standpoint of that. It's being justified because the crown still controls everything. Okay. Many lawyers consider that the surviving aspects of feudalism are quaint and harmless relics from the past and should be left alone. Yeah, well, of course, attorneys are going to argue that, because attorneys are the ones that have always made all the money on the transfer of everybody's land, because they made the law. The mixing of Roman civil law when William the Conqueror came over in 1066 and all the nefarious things that he did, like create the Doomsday Book and it abolished Allodial title and all of this garbage. They the attorneys after that, the filthy attorneys that came after that, the Knights Templars that continued to make the law more and more difficult, so that no one could do anything without one of them, is the reason why the system is the way it is. So that's why they think, that it's quaint and harmless relics from the past and should be left alone. No, it's because you rape everybody. It's because you're parasites. That's why. It's the only reason. Okay. So to continue, in fact, as this article attempts to demonstrate, what remains of feudalism does no good and a great deal of harm. Yes, that I will agree with. It is concerned with the two main relics of feudalism, the crown's ultimate residual paramount lordship and the doctrine of a sheet. All right, just to pause here for a moment. When they're speaking about the crown, they don't mean like the actual monarchy, okay? The crown is a corporation. Just like the United States is a corporation, which you can double check and look up under 28 USC 3001 or 3002, and then it's 15A, I believe. The crown's a corporation, never dies. The crown's a corporation, same as the United States. So, and the doctrine of a sheet. So they'll get into a sheet later in here, but basically what a sheet is that, in a nutshell. And a sheet is when someone dies or passes where there's no known heirs to be living, and also there's no written will as to what should happen or take place with the lands and the estate of the deceased. And so what happens is what's called an escheat, that the estate escheats back to the crown or to the king. And in the republic, in our republics in America, there are many states that have common law regarding escheats written into their constitutions themselves. Michigan's one of them. Michigan actually has a state board of escheats, which I and a colleague learned last summer that they had moved the powers of the State Board of Escheats to the Treasurer's office in Michigan. And so what that means is that the Treasurer is now holding all of your stuff. For DC, it works differently because DC is a corporation anyway, and the United States is a corporation anyway. What they do, instead of being the aspect of an escheat, what they do is they basically give the entire bar association the powers to administer all of the infants' property, which is all of us, because all of us have been abandoned at the foundling hospitals by contract, by the BC contract, and the guardians of the infants are trust companies. That's how DC plays it. So when the state governors transferred everything, they committed treason and transferred everything in 1933 to the feds for loans from a private banking cartel of all the property that was registered, not recorded, but registered on the state and county levels for loans from these parasites. Then what happened was that then DC became basically kind of the bailor, if you will, or then the holder of all of the rest of the estates that had been already gathered up, if you will, basically unlawfully on the state side through all kinds of nefarious means and the Torrens registry system, which I won't get into. But so then the aspect of a sheet, it continues and continues and continues to go back to the state. Now, what's supposed to happen in the Republic is that if some man, say, passes and he doesn't have any children, then the lands are put up as an estate sale, and the state's supposed to take care of that, and then we, the people, then come and buy either portions of or the entire part of that man's land, so it stays in the hands of the people. And that was supposed to pass. Then that was then supposed to pass allodial title to another one of the people, so the land always stayed perpetually in the hands of the people. That's how it's supposed to work. But as we'll get into with the Torrens registry system a little bit later tonight, you'll see that's not how it works anymore. But I just wanted to just give a little overview of a sheet real quick. Okay, so to continue. There is no attempt to engage in a scholarly discourse on the nature of either. It is enough to set out the principal elements of the law, which have been drawn from the standard courses such as Shelley's. The Crown's paramount lordship. As Lord Coke explained in his elaborate commentary on Littleton's tenures, 1826, all the lands within this realm are originally derived from the Crown, and therefore the King is sovereign or Lord Paramount, either immediate or immediate of all and every parcel of land within the realm. So that's basically what the description of that was, is that the king held allodial title. Every other title under allodial is less than. That's where you get into fee simple absolute, fee of years, and all other less titles under feudalism, which is where you get the word from, fee. So, to continue, originally there was a feudal pyramid in this country. In other words, all the lands were vested in the king, who granted land to the tenants in chief in return for services, a process called infeudation. Those tenants in chief, in turn, made sub-infeudatory grants to their followers in exchange for services, and those followers further subfeudated, so on and so forth, blah, blah, blah. Lords further down the feudal pyramid were called mens, or intermediate. Mens actually means middle, the middle lord. In other words, the only way of disposing of land was to grant it in return for services. This is what usually was called knight scoage, or shield payment. You fought for the king, you held title to the land, as long as you came when you were told to come fight. The statute Quaem Porus 1290, which is still on the statute book, abolished the practice of sub-infeudation. It prohibits feudal grants to tenants in fee simple in exchange for services. So what they wanted to stop was, they wanted to stop the growing of the feudal pyramid, if you will, because the guys up top were basically losing money. So I'm going to skip down a few sentences because all that gets into is the explanation of that. Okay, the statute of Quaem Porus did not bind the crown. It could not, because the crown could not transfer its paramount lordship to anybody. It could not, that was the point. It could not transfer allodial title. Allodial title was never transferred to anyone else. Now, there is an interesting understanding of what happened with the barons in 1215 and shifting of land rights, and particularly the shifting of the passing of estates by heir in the realm substantially changed in 1215 compared to what it had been under the continued laws set up and set down from the filthy Roman civil law from William the Conqueror from 1066. There was quite a bit of change in it. Next time we come back around to land title, I might take the whole rest of the class to just simply go over the Magna Carta to show that change. But for now, we'll just make a note here that there were major changes in how land was transferred. There were major changes in how the estates were settled. And because the Magna Carta is the basis of the common law, it is still good law here. And you can still use the common law here as long as you do it in a court of record and not in a filthy inferior court, not of record. That's basically a corporation for profit. So, okay, so to continue. It could not stop because the crown could not transfer paramount lordship to anyone. All right. All it could do was to grant a fee simple by way of infeudatory grant from its paramount ownership. That remains the case today as though any such grantee would not now do homage and services for the land granted him, but pay hard cash for it. Most of the vestiges of feudalism were finally swept away by the 10 Years Abolition Act of 1660. Now that's an interesting note here, that this 10 Years Abolition Act of 1660, only a few years after this did the filthy dark ones burn London to the ground, and then came in over the top with the Sestrique Act of 1666, which basically said, well, if you don't come forward and claim your estate, we don't know who you are, and you're basically all lost to the sea, lost in the sea of commerce, and you're all considered dead. Dead and lost beyond the sea. So we'll just administer everything, which was exactly what Nero did after they burned Rome to the ground. So typical modus operandi for these Luciferian scumbags. All right, to continue, the consequences of this are explained as a well-known textbook as follows. After 1290, the feudal pyramid began to crumble. Number of the men's lordships could not be increased. Evidence of existing men's lordship gradually disappeared with the passage of time, and so most land came to be held directly from the crown, which was, of course, that was the point, because what he doesn't say here is that part of the reason why Quia Emporis was also passed in 1290 was that there were many more people granting, or lords that were granting or giving lands to the church, because the cult of Rome had fully implanted itself into England, and which basically came to a crescendo during King John's reign of 1215, where King John tried to literally pledge all of the lands of England, all of them, to the Pope for loans, so he could go fight wars like his brother Richard the Lionheart and have glory and whatnot. And that was when the barons said, okay, enough of this shit. Nope, that's not happening. You either sign this Magna Carta or we're taking your filthy head off. And so he did. And then every king after that has confirmed the Magna Carta in what was called the Confirmare Cartarum, or the confirming charter, which is why the Magna Carta is still the common law of the land today, which we inherited here in America. So, all right, that was just another little roundabout, but I just wanted to add that in there, because you got to understand that the church had a lot to do with the movement and the reasons for a lot of these things being passed in England. So, just as an aside there. Okay, so to continue, there is a strong presumption that every freeholder holds his lands directly of the crown as its tenants-in-chief. In 1832, the Real Property Commissioners, in the third report on real property, commented that land is now most usually held immediately by the crown. In 1973, the Court of Appeals considered that the possibility of the emergence of the men's lord is one that is so remote that it may be wholly ignored for present purposes. However, the theoretical possibility of the existence of a men's lord may explain why the crown can own a freehold estate in land as well as having its paramount lordship. The freehold does not merge the crown's higher right. However, it is very questionable whether the crown could grant to itself a fee simple out of its paramount lordship. Well, of course it could if it wanted to, but they most likely wouldn't do that. It is not easy to see how the crown, one and indivisible as it is, can hold land as tenant-in-chief of itself. That point is not, as it happens, one that is entirely academic. There are two cases where the existence of a men's lordship is genuine. Those who own freeholds within one or other of the two royal duchesses of Cornwall and Lancaster hold them respectively of the Duke of Cornwall and of the crown in right of the Duchy of Lancaster. See, because you have these. See, this is where they're giving you a little bit of a hint as to still what's going on. All of these titles and these bloodlines still exist, and all these lordships and who they are and who they go to and so on and so forth, again, are still there. The chopping up of it never left, and what they wanted to do here was just reboot their system after we took it away from them. So to continue, there is one curiosity about the Crown's paramount lordship. It has no generally accepted name in English law, though it has been called absolute property. That's an aspect of, like, absolute title or absolute property. It's not quite the same as allodial, but that's about as far as they dare to go say it without actually using the word allodial, because they certainly don't want people to start using that word over there. They don't even like it when we use it over here. But anyway, it is also rather a curious form of ownership. As explained below, it is the ownership that can be without responsibility. One point that does need to be stressed is that the Crown's lordship is not an estate in land. English law developed almost by accident the doctrine of estates, that is, the idea of ownership in land can be divisible in time. The ownership of an estate is not the owner of the land. He does not have dominion directum. He merely owns the right to enjoy the land for a period of time. Even the largest estate, the fee simple absolute, may come to an end. Indeed, it is that fact that underlines this article. Now, that's the point to be taken there, is that that term, fee simple absolute, is the highest fee you can have, or the highest land title you can have, basically under feudalism / Roman civil law. But fee simple absolute is not allodial. Allodial is what the king has, and allodial is what we have, if we do what's necessary to claim and create the title, the allodial title, ourselves, because all of our land titles in America have been registered through the Torrens land registry system by somebody along the road of transfer, and therefore they're begging to have a king. They're begging to be ruled, and all one needs to come along is to claim it, properly do the declaration of allodial lands, and bring forth the land patent and make the proper claim. And then you have to boot everybody else out, which is an action of ejectment, which I think that's what I'll get to the next time we roll around for court class. I might go over an action of ejectment, which will be a nice dovetail to the land talks, because it'll be the next class. We'll after class 8, we'll go back to class 1. So now, as far as our estates are concerned, what they wrap us up into is that they wrap all of our things up into basically one trust, of which all of our estate is kind of basically stuck in, which is the aspect of a Sesquiquae trust. But that's the name, that's the all capital letters name on the birth certificate. That's the entire estate which you need to claim, which also includes your body and everything else, because you've been lost at sea and it's on bond paper and you're being administered and your productive value is being used, and there are very, very large bonds which correlate to that are being held at fidelity, and so on and so forth. So that's their new feudal system, if you will, is that everybody's in this type of economic feudal system for turning the entire human race into a human resource. So to continue, okay, so what's in a sheet? Circumstances occur where no longer any feudal tenant, the land returns by reason of tenure to the feudal lord who created the tenure. A sheet is a name given to this process by which the land reverted to the tenant's lord. As indicated above, outside the two royal duchies, there is a presumption that a fee simple owner holds his land directly from the crown and not of some intermediate lord. It follows that where a sheet occurs, the tenant's fee simple ends. If he held that fee simple in either of the royal duchesses, the land will still be held in fee simple, but it will be the prior fee simple of the mens or middle lord of the Duke of Cornwall, or crown in right of the Duchy of Lancaster. If, however, the tenant had held in fee simple of the crown holds the land in paramount ownership. So basically, they're just again saying that they've collapsed the pyramid, basically, for the exception of these few dukes and duchesses already previously spoken of. So if the crown subsequently grants the land afresh, it will do so by an infeudatory grant in fee simple. It is assumed that either the Royal Duchess can make infeudatory grants if they sell land that had escheated to them. Presumably do so by subsidiary grant instead. If that is correct, what would happen if the land were, once again, to escheat? Would it this time escheat to the crown? Question mark. Escheat is only complete when the lord to whom it reverts either enters on the land or takes process to recover it. Now again, here in the Republic, it's simply man dies, no heirs, no known living heirs, no will. It simply escheats back to the people, because we are the sovereignty of the Republic. And so then we just come forward, and whoever wishes to buy it, first come, first served, as long as it's distributed back up. Okay, at one time it was necessary for there to be an inquisition before an escheat could take place. Now, I love how they just throw that in there like so quick you don't even catch it. Okay. At one time it was necessary for there to be an inquisition before an escheat could take place. And I also love how they split it between the lines. Okay. It is extremely important to understand what an inquisition is. People hear the word and they go, oh, Spanish Inquisition. It's crazy people running around burning people at stake. No, not what it is. The aspect of an inquisition is actually an inquest. Okay, that's where the term comes from. It's an inquest. So you have, from these times and now also, because we're now doing them now, to correct and alter and abolish and get rid of the presumptions that filthy bar association is holding over us. We have developed proof of life and proof of age inquests, of which we appoint a judicial coroner to our own house, and then that judicial coroner summons a petite jury, and then that petite jury is presented with facts, evidence, and the law to determine on proof of life and proof of age inquest that 1, we've been found to be living, 2, that we have come of full age, and 3, that we're competent to handle our own affairs. Okay, those are the 3 major presumptions that they hold over you to be able to continue to administer every single thing we do. So that was something that everyone used to have to do during the time when the Court of Wards and Liveries was running in England. You can look up the Court of Wards and Liveries, and you can just, even if you just read the wiki's it's not that bad. It's actually a pretty good wiki. I've looked over it many times, and it has some very good background, and will give you the general gist of what the Court of Wards and Liveries was. But in a nutshell, what it was the place where when one of the members of the peerage had come of full age, and that was not a day, that was not a date, that was not a specific amount of years, by the way, it was just whenever they could handle their own affairs, they would sue out their livery. Okay, that was what it was called. They would sue out their livery. Livery is the root word of delivery. D is a prefix, French prefix, meaning of or from. Livery is to have and to hold. So they would sue out their livery against who? They would sue out their livery against their guardian. So if you were a ward of the king, you literally, when you had come of full age, and you knew what you were doing, you could handle your own and hold your own court, because that's exactly what they said, and that's exactly what it says in the Magna Carta as well, that no free man shall lose his court. And of course, all of the members of the peerage are freemen. That they would sue out livery against their guardian, open their own court, and they would do so through what was called the Court of Wards and Liveries. And they did this on a proof of age inquest. Okay, that's what was part of one of the court documents, if you will, for this whole process. So they would sue out their livery on a proof of age inquest, and then the court would deem that the ward had come of full age, because in the inquest there's actually an example of one, I believe, in the wiki on the Court of Wards and Liveries online, or it's part of the article perhaps. But anyway, you'll read that it was a long list of characters. A monk would come forward and write on the document, yes, I have known the said whoever for so long because I sued out writs from his father's house, yada yada. A knight would come forward and say, yes, I know that the sir whoever or that the young whoever is come of full age, because I have been a knight under his father for so many years and saw him born at age whatever, blah, blah, blah. And they'd continue to write out the rest of and other people would come forward, and yada, 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 saying that they knew the young whoever and that they knew that they'd come of full age, that they could handle their own affairs. And that was called a writ of proof of age inquest. Okay, so that was part of suing out one's livery. When they're talking about at one time it was necessary for there to be an inquisition before an escheat could take place, what they're talking about here, as far as an escheat could take place, is that the inquisition was done by the coroner to prove that so-and-so was dead and that he had no heirs, so that the escheat could then go back to whoever the higher lord was. And in this case, at a certain point, as they were saying here, at a certain point, it pretty much became just the crown. But that was also an inquest. An inquest is always a matter of life and limb as well, by the way. So it's always, always, always considered gratis under the Magna Carta, meaning it cannot be denied, because it's of these matters of life and limb of which we must continue in society to be able to transfer things when we're dead and gone. So that's why the escheats also required inquest. So, okay, so to continue. Indeed, the crown employed an escheator in every county to enforce its rights. Such inquisitions have long been obsolete and were formally abolished by the Crown Act of, get that, 1961. So guess what? Wasn't abolished over there till 1961. So it's still part of the common law and still an aspect of what they're doing to us over here. So anyway, there is one other curiosity about escheats that will be mentioned in this stage. For nearly 500 years, there was a view based in a dictum in Prior of Spalding's case from 1467 that was cited in Coke and Littleton, that the doctrine of escheat did not apply to a corporation. Well, ha, ha, ha. You see, that's where the king and the church have been going at it for a long time. Church never dies, people. Okay? When the church grabs a hold of land, it stays with the church forever. And that was the part of the problem. So, if a corporation was dissolved, which of course the filthy cult of Rome will never be dissolved, any lands which will be held reverted to the grantor. As Blackstone explained in his commentaries, the law doth annex a condition to every such grant, that if the corporation be dissolved, the grantor shall have the lands again, because the cause of the grant faileth. So basically it's got to go back to gave it to him. This view must have been based on the sort of charitable and I'm not exactly sure how to even pronounce that word, elementary corporations that Coke could have known in the early 17th century, because it seems oddly inappropriate in relation to joint stock companies. It did not receive its quietus until the decision of the Court of Appeals in 1933. Again, 1933, very late in this world. Ironically, it is in the context of insolvent companies that the last vestiges of feudalism are causing the most difficulty, and this is explained below. When does an escheat occur? At one time, the situation in which escheat occurred were fairly common, were two particular importance. When a person was convicted of any felony other than treason, in case of treason, there was forfeiture to the crown rather than escheat to the traitor's lord. Both this particular form of escheat and forfeiture were abolished not until 1870. Again, surprise, surprise. An estate escheated if the owner died intestate and without heirs. That's what I was speaking of, which was abolished by the Administration of Estates Act, which made provision for land to pass to the crown, or where relevant, the Duchy of Cornwall or Duchy of Lancaster, as bonification in lieu of any right to escheat. So again, they're just, notice these words. It was abolished by the Administration of Estates Act. Yeah. That's what they're doing here. The attorneys are administering all of our estates. Okay. But anyway, I've spoken enough about that tonight. So, to continue, although both the principal instances of escheat have now gone, it can still occur in a number of cases. All are associated with insolvency, and there have been history that goes back to the Bankruptcy Act of 1869. Where a freehold is disclaimed, there is necessarily an escheat. And this is now firmly established by line of authority going back to 1880. It was restated in 1995, blah, blah, blah. Yada, yada. Okay. There are three circumstances in which a freehold may be disclaimed. A trustee in bankruptcy may disclaim erroneous property. as unprofitable contract. Okay. And other property compromised in the bankrupt's estate, which is unsaleable or not readily saleable, or is such that it may give rise to a liability to pay money or perform any other erroneous act. Well, that's just an aspect that you can never be forced to take a benefit, and you can't. Yeah. Anyway, there is an analogous provision in 178 of the Insolvency Act of 1986 by which the liquidator of a company that is being wound up may disclaim erroneous property. Erroneous property is defined in the same way. Again, that's just the same thing that applied before. And again, when a company is dissolved, all its property is vested to the crown or Dutch free, blah, blah, blah. Okay, yeah. When a company is dissolved, hey, guess what? How about we dissolve the United States Federal Corporation tomorrow? That sounds like a good idea to me. So what the crown disclaims as bona fide vacancy or prominently acquires by way of a sheet. So basically they're just saying, yep, everything is just coming back to the crown, even if it was something that was held by a corporation. And here, proper way that would happen in the Republic is that corporations aren't allowed to own land at all. They can only have the right of use. And all of the categories, if you will, for land taxes at the county are all based on use. They're based on use and usufruct, and they're also based on aspects of commerce. The very word resident means that is someone who is in a place temporarily doing business, and when they're done doing business, they'll go back to wherever they came from. So the idea that you're a merchant basically renting the land to do business here is a presumption, a rebuttable presumption, that the county uses to make you pay property tax. Okay, which is clearly outshadowed and seen and understood by the fact that you can go and get a homestead exemption. And this is my homestead. No, I'm not a resident. This is my lawful domicile. So you can have many residencies. You can only have one domicile. Then you get homestead exemption. Or you can go the route of, look, I'm claiming this. I'm giving the county notice. I'm bringing forward the land patent. I am creating the declaration of allodial lands. So I'm creating a allodial title. I'm standing on a allodial title, and I'm ejecting everyone through an action of ejectment, including the county and anybody else that wants to come against you, and stand firm on it and actually retake the land as allodial. That's the other way to do it. Okay, so to continue, I'm not going to get through the rest of that one. So I'll stop there for now for the understanding about how the sheets, so everybody pretty much understands the aspect of sheets. I'll skip the consequences part, and I will move on down to the doctrine of estates. So I'll go down to page 4. All right, doctrine of estates, this little pink section. One point that does not need to be stressed is that the crown's lordship is not an estate in land. An estate in land is a degree of ownership. Okay, that's basically the substantive definition of the word estate, is a degree or amount of ownership in something, in some res. Technically, in law, you should not think of an estate as a thing. You should think of an estate as an amount of ownership in something. However, there are clearly places in law where they speak of the administration of the estate. Bankruptcy is a good example of that. IRS forms are a good example of that. All W-9 and 1040 forms are Class 5. And Class 5 is gift and estate tax. Okay, so you're being taxed to use what? Your own stuff? Well, because you haven't claimed it, and you're still an infant, because you haven't unwound yourself from this filthy feudal system yet. So anyway, not to digress. All right. So to continue, English law developed almost by accident the doctrine of estates, that is, the idea that ownership in land can be divisible in time. The owner of an estate is not the owner of the land. He does not have dominium directium, or direct dominion over the land. He merely owns the right to enjoy the land for a period of time. Again, that's the idea that an estate is an aspect or an amount of ownership, or amount of right. It's basically an amount of right to do something. Even the largest estate, the fee simple absolute, may come to an end. Okay. Now, that's all an aspect of feudal tenure, so just remember that. our estates in our lands and our bodies and our rights and our children are always allodial. They're always absolute, because there's nothing higher in the constitutional republic than the people. So just the problem is that the people keep entering into contract with the corporate state, and then that creates and continues the presumption, which is the problem. So I won't get into that. I just want to read that little part of a state so that people understood that. So now let's basically end. We'll just end on that one, and let's get into the State Illinois Conveyances Act next. This is a Illinois statute regarding the conveyance of land, and I wanted to show everyone the importance of some of this law about some of these things that we're talking about, that because somebody might say, well, what is feudalism? Doesn't have anything to do with what we're doing here. And you'll have attorneys say that all the time. Oh, feudalism doesn't have, well, those laws don't have anything to do with what we're doing in here in the state of Illinois or the state of bullshit. Yes, they do. Yes, they do, and they always have. Any filthy attorney that tells you otherwise is just flat lying to you, which you can now read. Okay, the Illinois Statutes Conveyances Act, property. Conveyances, short title may be cited as the Conveyances Act. Okay, so there we go. Chapter 30, Part 1. Section 1. Livery of season. Interesting term, right? Where'd that come from? Shall in no case be necessary for the conveyance of real property. Now, livery of season is different than suing out one's livery. Livery of season was a ritual of which two people went onto the land, one who was the buyer, one who was the seller, and they would ceremoniously exchange gold or whatever they were exchanging, and the seller of the land would literally take a clump of dirt and or a stick or some grass and put it in the hand of the other with witnesses. That was called livery of season. And there was a time where if you did not do that, and there were not witnesses to that, you did not own the land. So just remember that livery of season was this ritual that I just said, and is different than suing out one's livery, which I spoke of before. So just to make that clear. Okay, so livery of season shall in no case be necessary for the conveyance of real property, but every deed, mortgage, or other conveyance in writing not procured by duress, right? So not being forced, and signed by the party making the same, the maker or makers, being of full age, and sound mind. Now, does that say the age of majority? No, it does not. That says being of full age. That comes directly from the Magna Carta. That is over 650 years of unambiguous jurisprudence staring you in the face. So do not let any filthy attorney tell you that, one, the common law is not in full force and effect, or two, that any of these things in England have nothing to do with what we're doing here. They do. Okay? All right, so the maker or makers being of full age and sound mind shall be sufficient, without livery of season, which is that ritual, for giving, granting, selling, mortgaging, leasing, or otherwise conveying or transferring any lands, tenements, or hereditaments. Okay, now if anybody doesn't know what a hereditament is, a hereditament is basically a right that passes from someone to their posterity. So, tenement or hereditaments in this state. So notice that, in this state, lowercase s state, not uppercase. Okay, so that means actually in the republic. So as to all intents and purposes, absolutely and fully to vest in every donee, grantee, bargainee, mortgagee, lessee, or purchaser all such estate or estates as shall be specified in any such deed, mortgage, lease, or other conveyance. Nothing here. Now this is a very, very, very important line. Nothing herein contained shall be so construed as to divest or defeat the older or better estate or right of any person or persons not party to such deed, mortgage, lease, or other conveyance. What does that mean? It means that at any point in time, if they've screwed up the land record or they're doing their nefarious, they just gave themselves an out right there, okay? They said, if you do actually figure out that you own the land, and you do actually figure out that you're the assigns of the assigns of the assigns, or the fact that simply the fact that the land is abandoned and you create the better estate, you see, the older or better estate. The better estate would be title and allodium. Okay, that's the better estate. That's the better claim, the better right. Because if you hold both, see how they split up title. I covered this last time, but it's important that I say it again. How they split up title in Roman civil law is they have an equitable title and a legal title. The legal title is, okay, you have the right to own it. The equitable title is, oh, you have the right to use it. But never shall the two merge, basically, is what the deal is. You can have both of them, and then that's the idea of an absolute estate. But it's still that somewhere you have to register the thing, which is the whole 9/10 of the law. That possession is 9/10 of the law, but there's one last 1/10 of the law, which is called occupartii, which means that you have to register your stuff with Caesar to say, yeah, it's registered with the state. And if it's not in the Roman rolls, or current day feudalism, in the Torrens land registry system, you don't actually own it. Well, bullshit. That's them trying to steal the whole world again by creating documents, which is what the Romans have always done. So, just to make a point again, to read this again, nothing herein contained shall be so construed as to divest or defeat the older or better estate or right of any person or persons. Now, of course, you're not a person or person, but I won't get into that right now. Not party to such deed, mortgage, lease, or other conveyance. So they're giving themselves an out, and they're also saying, look, you know what? There might be a better estate or older estate out there somewhere, and you probably should be aware of it. Okay. So to continue the second part, part 2, every estate, gift, grant, deed, mortgage, lease, release, or confirmation of lands, tenements, rents, services, or hereditaments made or had, or hereafter to be made or had by any person or persons, being of full age and sound mind, there's that being of full age again, and not procured by duress to any person or persons, and all recoveries, judgments, and enforcements had or made, judgments, or enforcements had or made, or to be had or made, shall be good and effectual to him, her, or them, to whom it is or shall be made, had or given, and to all others to his or their her use against the judgment debtor, seller, grantor, mortgage, or lessor. Judgment debtor? Notice that. And against his, her, or their heirs. So their heirs. Okay, not their successors, because that's what corporations have. Only living men and women have heirs. Corporations don't have heirs. Corporations have successors. Okay. Claiming the same only as heir or heirs, and each of them, and against all others having or claiming any title or interest in the same, only to the use of the same judgment debtor, seller, grantor, mortgagor, blah, 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 or his or their heirs at the time of judgment, enforcement, bargain, sale, mortgage, blah, 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 blah. Okay, so that's what all that rigmarole basically was saying, look, the aspect of use, okay, in the interest of his or her heirs, the use, only to the use of the same judgment. Okay, so they're showing you that there's a major difference between that all of the things that were done by the aspect of hereditaments and lawful heirs shall be good of all of that stuff, as long as you're claiming the same only as heir or heirs. Okay, not a beneficiary, not a successor, an heir. It's important to understand that the two most powerful positions that we have when we're dealing with the corporate state and making sure that we're in control of our estate is executor and heir. We're the executor of the estate, which puts us above any administrator, which I have the examples of executors versus administrators in another class section. But you should know the difference between executor and administrator. And just in a nutshell, an executor is one done by will. An administrator is one done by a court or by an attorney, of which there is no will for the said man or woman, and they're basically intestate. So what we do is we appoint ourselves as executor of our own estates, because we can do that by a Power of Appointment Act in 1951, because the donor is the one that has all the power. The donor decides who goes in all the positions. Okay. So we appoint ourselves as executor. We appoint all of the rest of the corporate state. Everybody. Basically, you appoint everybody that's not a member of your house as a trustee of your estate and say to them, look, here's an offer of contract. I appoint everybody in the entire world except the members of my house as trustees of my estate. The only way that you accept that trustee appointment, however, is if you come and attempt to administer any part of my estate. Because here's the thing, you're sure as hell not going to be the beneficiary of my estate, and you're sure as hell not going to be an administrator or executor of my estate. You're going to be a trustee, what you were always meant to have been as far as the trustees of government, okay? The people vest the power to the trustees to go do yada, yada, yada. And when they're doing something more than yada, 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 and they jump out of their box, you divest them of their power and say, you're no longer a trustee because you're an idiot. And you put criminal charges on them and you get rid of them. That's how all this is supposed to work. If anybody doesn't quite believe that, you should go read the original Bill of Rights of the Virginia Constitution. I believe it's the second line, and clearly, might even be the first line, clearly lays out what the positions of the magistrates and judges are, okay? Without question. So, interesting little homework assignment if anybody wants to go look that up. Believe me, it's worth your read. They've always been the trustees. They always will be the trustees. We just have to keep them there. And we have to put a stiff penalty when they come out of, or thinking that they can come out and do anything but be a trustee. But to do that, you have to have corrected your status already with the status docs and put it on the public record, served the appropriate trustees, and then defaulted them. And then you can move forward in courts of record or binding arbitration, however you want to do it, because the status docs allow for multiple different ways for enforcement, or even grand jury for that matter, when we get proper 25 in each state, where 25 men and women have done the status docs and then can actually properly, once and for all, since all the way back from the days of the mid-1800s, properly convene a 25-member grand jury and put everybody back in their box. That's the goal here at the National Popular Assembly, is to teach people and to get them to the point of being able to sit on a grand jury with intelligence, integrity, understanding law, understanding due process, which is making sure that both the defendant and the plaintiff's rights are protected, so that our substantive rights, which we secure through the constitutions, which are the common laws of the land, are no longer diminished, but are strengthened by our combined effort to know, learn, and teach those substantive rights, which of course is the study of civics. Civics is the study of one's personal rights, and that's been absolutely eviscerated in the Prussian education system. So with that, getting on to 8 o'clock, it'll be a long time coming. Be 2 months until we come back to land issues again. So anything in the land section in Class 8 docs, obviously feel free to read over until the next time. And that will conclude tonight's class for National Popular Assembly Discord. This was Class 8, Land Title, Land Issues, Property Taxes, and Allodial Title. And the next class will go back to Class 1, which will be this next coming Wednesday, where we will go back to covering jurisdiction, court process, and grand jury process. And now we can talk amongst ourselves.